afternoon, smooth operators. This is Raymond De Leon with Smoothoperationoflaw, and today is January 5th, 2021. Today's topic is the Foreign Sovereign Immunity Act. Make sure you hit that like, share, or subscribe button, and I would prefer that all of you subscribe and share and like so that you can allow this video to be moved up on the YouTube algorithm and be spread further and farther as we get these messages of truth out to people, okay? If you so choose, please hit that notification bell and allow all of Smooth Operations videos to be notified directly to you so that you don't miss a beat when we upload a video daily. Today's topic, again, is the Foreign Sovereign Immunities Act. And the Foreign Sovereign Immunity Act is a very, very special tool. This is how you waive a state agency's immunity, its instrumentalities, immunity, a foreign government's immunity, a foreign corporation's immunity. So anybody that sits there and they're in a company and they're saying, hey man, you know what, you can't really sue us because no jurisdiction, or they claim that the party that's suing usually has a lack of standing. This is the act right here that will allow you to do a concept that's called piercing the corporate veil. When you pierce a corporate veil, what you're doing is you are waiving that entity's immunity. Some act that they might have taken or conducted will be sufficient, if proven in a courtroom, to pierce their immunity. I said it slow so that you guys can understand it, and now let's get into this. Foreign Sovereign Immunities Act. The Foreign Sovereign Immunity Act of 1976 is a United States law codified at Title 28, Section 1330, 1332, 1391F, 1441D, and 1602 to 1611 of the United States Code that establishes the limitations as to whether a foreign sovereign nation or its political subdivisions, agencies, or instrumentalities may be sued in U.S. courts, federal or state. In international law, government protection against lawsuits in foreign courts is known as state immunity. Government immunity in domestic courts is known as sovereign immunity. It also establishes specific procedures for service of process, attachment of property, and execution of judgment in proceedings against a foreign state. The Foreign Sovereign Immunity Act provides the exclusive basis and means to bring a lawsuit against a foreign sovereign in the United States. It was signed into law by United States President Gerald Ford on October 21st, 1976. What we need to know is that there is a veil-piercing mechanism that is very straight, meaning if you prove this, it doesn't matter what they say, they are liable if you prove what I'm about to say. There is a commercial activity exception. The most important exception to sovereign immunity is the commercial activity exception, 28 U.S.C. 1605 A2. This section provides three bases on which a plaintiff can sue a foreign state. When the plaintiff's claim is based upon a commercial activity carried on in the United States by the foreign state, when the plaintiff's claim is based upon an act by the foreign state which is performed in the United States in connection with commercial activity outside the United States, and when the plaintiff's claim is based upon an act by a foreign state which is performed outside the United States in connection with commercial activity outside the United States, and which causes a direct effect in the United States. All right. So in determining whether the foreign state's activities are commercial, the Foreign Sovereign Immunity Act requires the courts look to the nature of the act itself rather than the purpose for which the foreign sovereign engaged in the act. 28 U.S.C. Section 1603D. For example, the operation of a free-based transportation system would likely be a commercial act, while imposing fines for parking tickets would be a public act, even if the former was undertaken to provide a public service and the latter was initiated to raise revenue. All right. So now, while imposing fines for parking tickets would be a public act. Yes, that would be considered a public act. But that is only if the party who happens to be a defendant from that public act is being charged. Now I'm going to show you something. That nature of the act is very important because the nature of the act, when described in a party's claim, is what matters in the application of the Foreign Sovereign Immunity Act's commercial activity exception. I'm going to say that more lame. If you claim, you better claim against that state in such a way that you describe the nature of the state's act as commercial. So what if you can construct an argument that makes or appears to make the state appear to be conducting a commercial activity, and you support with evidence? Could you waive a state's sovereign immunity? The answer is abso-fucking-lutely. In a courtroom, it's about what the issues are, who can prove what, and if you can prove what I just said as a concept and materialize it for that judge, you will be able to, regardless of the explanation that the state gives, get whatever their act was evaluated in such a scope of commercial intent. And I'm going to show you how. Whoops, just turn the screen. Okay. Hold on. I have to move through screens. So, there we go. We are going to take a look at 15 U.S.C. 1122. I made a video a few days ago, okay, about common law trademarks. If you'd like to come up to speed to understand the entire concept of what I'm about to say, you can go ahead and look at that video from a few days ago. I believe it's 4 days ago that I made the video, and I've been releasing pretty much just about every day or every other day. So it should be 4 videos earlier from this position. And if I'm mistaken, oh well, it's somewhere 4 or 5 videos ago. Okay? So now, 15 U.S. Code, Section 1122 falls under the Lanham Act for trademark, right? And we said that we're going to take our name and we're going to make it a trademark. That way it becomes a commercial asset. So liability of the United States and instrumentalities of officials thereof. A waiver of sovereign immunity by the United States. The United States, all agencies and instrumentalities thereof, and all individuals, firms, corporations, other persons acting for the United States and with the authorization and consent of the United States shall not be immune from suit in federal or state court by any person, including any governmental or non-governmental entity, for any violation under this chapter. And B is going to talk about the waiver of sovereign immunity of the states. And C is going to talk about your remedies. And then it ends. If you'd like to read the entire statute, I gave it to you. It's Title 15, United States Code, Section 1122. Okay? So I'm going to make this as simple as possible. If the state gives an individual a parking ticket, that is considered a public act. Well, what happens if you have a entity or a business that controls your name as a trademark? It is not subject to that public act. So that entity can walk into a courtroom and actually claim a trademark infringement, which is a commercial act, which by statute waives sovereign immunity against the state. And then the nature of the fact that they use that trademark in their capacities to make money, get some sort of funding, creates a Fourth Amendment violation of a commercial asset against the state. The victim is your entity. The nature of the act was that they used it for some form of independent contractor, agency, or instrumentality or state gain. That is why Title 15 has that the liability of the United States is a waiver of sovereign immunity by the United States. And it also explains in B, and the states. The nature of the claimant's argument is not going to be about a parking ticket. The nature of the claim of the plaintiff or claimant is going to be about trademark infringement. And although the state used it against a public act, against a defendant, your entity, not being a defendant in that case, is an innocent party. And it's not arguing about the state's ability to police. The nature of the argument is that the state enriched itself commercially, financially, off of a trademark. That is how you activate the commercial activity exception of Title 28, Section 1605A2. Wait, excuse me. Let me make sure that I'm saying that right. I don't want to say it wrong. 5A, sorry. 5A. So the commercial activity, let me pull it up. 1605A2. Sorry, I said it right the first time. Okay. So, Title 28, United States Code, Section 1605A2. Okay? Don't argue about the fact that the state gave a ticket. Just let your entity that you created that controls that name and is conducting business argue the fact of a trademark infringement over the enrichment of the state entity, therefore waiving its sovereign immunity, and that waiver is known as piercing the corporate veil, or waiver of sovereign immunity. And you will see how fast an injunction will be provided for your entity's benefit, which will inherently leave you as an individual without a debt, because it stops the state's ability to conduct the action of infringement. And so where they have quasi-criminal law and quasi-fucking reasons to go ahead and dump your pockets, you're wondering how you stay free? You must be smarter than the guys that are operating in the office who are conducting law as business as usual. You hit them with something like this, they're going to get a reality check. I know firsthand. They are going to get a reality check. Easy. So that concludes today's Foreign Sovereign Immunity Act and Commercial Activity Exception video. And I hope that when I'm sitting up here talking slow and I'm dragging my sentences out, the information that I'm stating is coming across clear and embedding itself in your ears. You can't argue this. There is law that provides for exactly what I just said, and it was on your screen. Conducting a cursory search right on Google. And for those of you who believe that you have a better answer, go ahead and blow up my comment section. I'd love to see what you think. Have a good day. Like, subscribe, share. Let's blow this thing out the water. This is all free information. It's not practicing law without a license, okay? I'm not an attorney, and this ain't legal advice. I'm just showing evidentiary facts that exist by their own words. Have a good day.